So the moment the male head of the household dies in the ancient world, whether he was the kyrios in Athens or the paterfamilias in Rome, the entire family structure, well, it teeters. For
Absolutely.
any minor children, it's a profound legal and social crisis. I mean, without that adult male authority, they become instantly one of the most vulnerable people in the ancient polis or republic, legally incapable of managing their own affairs, property, or, standing up for themselves in court.
It's an immense vulnerability, yeah. And our sources today really demonstrate that both Athens and Rome, they recognized this immediate threat. They developed these fantastically complex legal mechanisms, not just to sort of console the child, but critically to ensure the family's assets, the property, and the dynastic lineage survived intact.
Right.
Because, for ancient society, the stable oikos or household was basically the bedrock of the state. If the property dissolved, the family status dissolved, and social stability was, well, it was jeopardized.
And here's where it gets really interesting, I think. These systems reveal two very different approaches to solving the same fundamental problem. You've got Athens, highly reliant on kinship and maybe social pressure.
Mm-hmm.
And then Rome, which built this intricate, almost bureaucratic legal firewall designed, it seems, primarily for financial recovery.
Yeah.
Our deep dive today is really a comparison of these frameworks.
Exactly. And our mission really is to understand how these systems managed risk. We're going to explore that dangerous pattern of guardian misconduct in Athens where, relying on the closest kin often, well, it often failed.
Yeah.
Then we'll contrast that with the astonishing level of legal detail in Rome, including that protective mechanism of restitutio in integrum, that sort of legal reset button, designed to wipe out a minor's bad contracts and preserve their inheritance.
Okay, let's unpack this. Let's start in Athens. We really have to begin with the foundation of power there,
Yeah.
the kyrios, the head of the house. This role, it defined the authority structure over women and minors, and it was absolutely central to Athenian life, wasn't it?
Yeah. Oh, completely central. The authority of the kyrios was sweeping and long-lasting. When we look at the laws defining who inherited this authority, particularly the right to grant a woman's hand in marriage through engix, the formal betrothal that permits legitimate children, the rules are incredibly precise.
Why so precise?
Because they are prioritizing the male lineage above all else. It's all about who carries the line forward.
Okay, so I see the hierarchy laid out in the sources.
Mm-hmm.
The father first, naturally. That makes sense. But who's next? And why that specific person? What's the logic there?
Right, so if the father was deceased, the authority passed to the homopatric brother. And that term, homopatric, is crucial here.
Homopatric.
It means the brother born from the same father. It ensures the authority stays strictly within the male line of descent. Not just any brother, but one sharing the same father.
Got it. Keeps it tight within the paternal line.
Exactly. And if no homopatric brother existed, then the authority would fall to the paternal grandfather. This clear prioritization of the father's line, the agnates, it dictates the entire legal landscape of dependence. It's a system designed explicitly to keep authority and, crucially, property control within that circle of kin defined by the male progenitor.
That makes sense for minors, definitely.
Yeah.
But the sources indicate this control wasn't temporary, not even for adult women. We tend to think of marriage as, the point of independence, maybe.
Mm-hmm.
But the original kyrios retained significant power over the woman, even after she was married off into a new household.
Yeah, that is one of the most eye-opening details about Athenian social structure, isn't it? The original kyrios, the father or the brother, was still considered the ultimate authority figure. He retained the right to arrange her divorce and remarriage.
Even after she's married.
Even after she's married. And look, this wasn't just some ceremonial right. It was exercised in practice.
Yeah.
And for very specific economic and social reasons cited right there in the sources.
Okay, so what were the most common triggers? When would that original kyrios step back into his sister's or daughter's married life and say, right, that's it?
Well, there were several major red flags. Childlessness was one, a big one.
Because the point was heirs.
Exactly. The primary purpose of marriage was reproduction to secure the lineage. If that failed, the kyrios might intervene to arrange a new union, find someone who could produce heirs for the line. Another reason was open conflict, perhaps between the father and the son-in-law. But maybe the most illustrative conflict involved the management of the dowry.
The money.
Always the money, right. If the husband began squandering the dowry, which was the family's financial stake in the marriage, often quite substantial, the original kyrios had the right, maybe even the duty, to intervene. He could reclaim the woman, protect that family asset, and arrange a remarriage. The woman's personal status was functionally inseparable from the financial preservation of her original family's wealth.
So protecting the dowry was essentially protecting the oiko's future standing and resources, no matter where the woman was actually living at the time.
Precisely. It all comes back to the oikos.
And we also see that this authority, this kyrios role, it could be shared sometimes. Like if there were multiple homopatric brothers, they often shared the role jointly.
Yes, they could share it jointly, and sometimes the kyrios could even delegate his authority, though this was clearly done only under specific circumstances of established trust. You needed to really trust the person.
Like the example in the sources.
Yeah, there's a case cited where a young man allowed his trusty stepfather to betroth his sister. So it shows the system, while rigid, it did have some flexibility built in. However, even when delegated, the ultimate accountability, the legal responsibility, it remained with the legally defined kyrios. The entire society hinged on this structure, where the oikos, the family unit, was the fundamental unit defining norms. And preserving its property and its lineage was, well, it was the law's primary concern.
That structural priority, preserving the oikos, it pushes us back to that idea of agnatic kinship, the male line again. Just how pervasive was this legal obsession with the male line? Did it show up elsewhere?
Oh, it was absolutely pervasive is the right word. It even twisted the rules of, well, what we'd consider incest today. Athenian law permitted, and sometimes even encouraged, the marriage of half-siblings on the father's side.
Wait, really? They allowed marriage between paternal half-siblings?
They did, but they strictly prohibited marriage between half-siblings on the mother's side.
Why on earth would they legalize marriage between paternal half-siblings? That seems counterintuitive from our modern perspective.
Well, legal scholars argue, and it seems pretty convincing, that this was almost certainly a measure intended to unify property within the Ankisteia.
The Ankisteia, that's the inner circle of kin, right?
Exactly. Roughly first cousins and closer. They had specific rights and duties regarding the estate, inheritance, that kind of thing. By allowing paternal half-siblings to marry, any scattered inherited wealth from their common father could be legally concentrated and kept within that defined circle. It reinforced the priority of inherited wealth flowing exclusively through the male lineage.
Wow. So it's a really powerful example of property law basically overriding biological or social prohibitions just to achieve dynastic continuity. Keep the wealth in the family name.
Keep the wealth in the male line of the family name. That's the key.
Okay, so the system is beautifully designed, in a way, to preserve property and lineage through the closest male kin. But this brings us right to the core dilemma of this whole section, doesn't it? What happens when the person best positioned to protect the property is also the person most tempted to steal it? When the guardian becomes the ultimate threat?
This is the fatal recurring problem in the Athenian system, and our sources highlight it again and again. The person most often appointed, or the one most entitled by law to become the guardian of an orphan, and thus the guardian of the oikos' assets, was usually the deceased father's brother, the paternal uncle.
And why him specifically?
Because he was the closest agnate. He was the person next in line for the property if the children failed to reach adulthood or if they died childless later on.
That creates a disastrous conflict of interest, surely. The uncle inherits the duty of protection, but he also possesses a direct, vested, and often immediate interest in the failure or, frankly, the ruin of his own nephew and niece.
Precisely. It's a terrible setup, and the source material is just rife with evidence documenting this systemic risk. We don't just have one or two isolated incidents, Multiple legal cases illustrate the maltreatment of orphans specifically at the hands of their paternal uncles.
So it wasn't just a theoretical risk, it was happening.
It suggests that the inherent temptation posed by the guardian role was a recognized and highly dangerous vulnerability within the Athenian social and legal structure. The law relied heavily on social honor, on the moral obligations of kinship, and frankly, those obligations frequently failed when substantial assets were at stake.
Can you give us a sense of what that maltreatment often looked like? Was it like outright cruelty or more subtle financial stuff?
It was overwhelmingly financial, though personal cruelty could certainly be a byproduct, I imagine. It could involve systematically mismanaging the family land to run it down, maybe claiming the estate owed the guardian debts that didn't actually exist.
Fictitious debts.
Fictitious debts, yeah. Or simply liquidating assets, selling off property or slaves, and using the proceeds personally, all the while knowing the minor was legally incapable of challenging these actions until they reached majority.
So the kid couldn't do anything about it until they grew up.
Exactly. The legal system was often left playing catch-up. It relied on the adult minor, once they came of age, to sue their former guardian to try and recover what was lost. And that was a messy, difficult, and often incomplete process, as you can imagine.
It really seems like the Athenian system, while maybe noble in its intent to keep property within the family line, was just fundamentally vulnerable to internal corruption. It placed temptation squarely in the hands of the closest heirs.
It was a structural trade-off, wasn't it? They prioritized the tightness of the Ankisteia circle, that inner group of kin, but in doing so, they essentially put the potentially most ambitious, maybe the most greedy members of that circle, in charge of the most vulnerable assets.
And we even see the deceased trying to exert control over the future, right? Trying to manage potential disputes, even from the grave.
Yes, look at the technical language they used. The verb episkeptein, it means to enjoin. It describes dying injunctions.
So not just requests, but commands.
These weren't just pieces of advice, these were legally binding final commands, often regarding matters of vengeance and homicide cases, interestingly, but also setting out expectations for household management, who should marry whom, that kind of thing. This detail really reinforces the immense authority of the patriarch. It shows that even after death, his final word carried massive legal weight over his household's future actions and familial relations. It was like a final, perhaps desperate attempt to impose order on a system prone to chaos upon his absence.
That's a really powerful picture of an inheritance system based so heavily on kinship trust. A trust that, it seems, often led to disappointment in litigation.
Yeah.
Okay, now let's contrast that. Let's move to Rome. We're shifting, it feels like, from a reliance on the morality of kin to a reliance on, legal precision.
That's a great way to put it. The transition to Rome shows a legal mindset that seems to anticipate fraud and corruption. It designs a system to mitigate it through sheer procedural complexity. In Rome, the dependent minor was the pupillus, and his guardian was the tutor. And Roman jurists were intensely focused on the contractual vulnerability of the pupillus.
Okay, what does that contractual vulnerability mean in practice? How did it play out?
Well, it basically means that a pupillus was generally incapable of entering into obligations that would legally harm their estate on their own. If they tried to buy or sell property or assume a debt, their actions were either void or voidable unless, and this is key, unless they had the express authorization, the auctoritas, of their tutor.
So the tutor had to sign off on it.
The tutor had to give formal authority. But, of course, this necessity of the tutor's authorization created a new problem. What happens when the tutor himself facilitates the fraud or is in on it?
Right. That is the exact situation we saw causing so much trouble in Athens.
Mm-hmm.
How did Rome create a system to protect the minor from both the external cheat and the internal colluding guardian? That seems like the real challenge.
This is where the Roman legal prioritization becomes really key, and it shows the Roman state prioritizing the guardian's accountability above almost everything else. So imagine our minor pupillus is cheated by some outside party, let's call him Titius. And Titius was in collusion with the tutor, who provided the necessary auctoritas.
Okay, the classic scenario.
Right, the pupillus had two potential legal remedies, but, and this is crucial, they were strictly sequenced. You had to do them in order.
Walk us through the sequence then. Which action came first? What was step one?
Step one, the primary remedy, was the action on tutelage. It's called the actio tutelae. This was brought directly against the tutor. This was the legal mechanism specifically designed to recover the minor's full interest and, importantly, to penalize the guardian for breach of their fiduciary duty. The state's first non-negotiable step was always to hold the designated guardian financially responsible for the mismanagement or the loss.
So the state essentially views the tutor as their primary shield for the minor's assets. Only if that shield fails, if the tutor can't pay up, do they look externally.
Absolutely. That's exactly right. The second remedy was the action for fraud, the actio doli, against the external party Titius. But crucially, the sources indicate this action against Titius was only granted if the tutor was found to be insolvent.
Insolvent
Meaning, he had no assets left to repay the estate. He was broke. This is a powerful demonstration of the Roman focus. They made the guardian financially responsible first. They ensured the risk was borne by the adult appointed to the role. The state essentially said, look, we appointed you, or your father appointed you in his will, you pay for the failure. This protected the patrimony, the inherited wealth, by forcing the guardian to absorb the risk of loss.
That level of detail really shows the state proactively trying to manage the financial risk associated with guardianship. It's quite different from the Athenian approach.
Right.
But what if the minor simply made a terrible decision due to inexperience? Without any outright fraud or collusion involved? Just a kid making a bad deal. How do they manage honest but potentially catastrophic mistakes?
Ah, that is where the really famous legal concept of restitutio in integrum comes in.
Restitutio in integram.
Literally translated, it means restoration to the original status. And it was the ultimate protection mechanism for minors. It ensured that minors were not permanently liable for obligations they incurred when they were placed at a legal or financial disadvantage simply because of their age and, well, their lack of judgment. It was like a legal undo button.
An undo button. That sounds like an unparalleled legal safety net.
Mm-hmm.
How sweeping was its power? How much could it undo?
Oh, it was exceptionally broad, almost a complete legal reset for the minor's contractual life during their minority. The minor could seek restitutio in integrum not just against the original creditor who made the bad deal with them,
Okay.
but also against any guarantor who entered into the obligation on the minor's behalf. So imagine an adult friend or maybe a relative guaranteed a bad loan for the minor. Restitutio could potentially nullify the obligation for both the minor and the guarantor who tried to help them.
Wow, so even the guarantor could be let off the hook.
Potentially, yes, because the root of the obligation was flawed due to the minor's incapacity.
And the protection extended beyond just the contractual debt itself, right? The sources mention it applying against the property itself.
Yeah.
That seems like a massive expansion of protection.
It is. It's huge. And it really demonstrates that the primary goal here was preserving the minor's inherited property, the patrimony. Let's use a clear example to see how this works. A pupillus, maybe foolishly, sells a valuable inherited statue for way less than it's worth.
Yep.
The buyer, let's call him Marcus, knows he got a steal. Marcus then immediately turns around and sells the statue to an entirely innocent third party, Caius, who pays a fair price and now possesses it.
Right, Caius thinks he's bought it legitimately.
Exactly. But the pupillus could seek restitutio in integrum, meaning against Caius, the current possessor of the property, even though Caius did nothing wrong.
Wait, hang on. So even if Caius, the third party, acted completely in good faith, paid fair market value to Marcus, the minor could still potentially reclaim the statue from him.
Yeah.
That's intense protection. It effectively subordinates the security of normal property transfer to the security of the minor's estate.
That's precisely it. The minor's claim to their ancestral property under these specific circumstances could supersede even the good faith of an outside purchaser. This highlights the Roman legal system's deep, deep commitment to the preservation of inherited wealth above almost all else. The property had to be returned to the estate.
And what happened to poor Caius then?
Well, Caius would then have to pursue the fraudulent intermediary, Marcus, for his losses. But the primary goal was achieved. The statue was back in the minor's patrimony. The entire apparatus was designed to stabilize the family wealth first and sort out external fairness second.
This level of legal detail also extended to ensuring the guardian, the tutor, was personally liable for financial exposure too, right? Creating yet another disincentive for misconduct or carelessness.
Yes, absolutely. The tutor was not merely an administrator, he was a potential financial absorber of the estate's liabilities. Guardians could be held personally liable for obligations related to their pupilli's contracts, especially if the contract involved a formal oral promise known as a stipulatio.
A formal promise.
A very formal, binding promise. Or they could be held liable through a specific action related to money obligations called the actio de pecunia constituta. These measures essentially force the adult guardian to act with extreme caution, knowing that the financial burden of failure, or even just a bad judgment call that harmed the estate, could fall squarely on them personally, not just on the child's inheritance.
So there were real teeth to the tutor's responsibility. And all of these guardianship laws, they seem built around the need to preserve the most important components of Roman family wealth. This points us back to that ancient classification of property itself, doesn't it?
That's exactly right. The foundation of inherited status, particularly for the Roman elite, rested upon specific crucial assets. These were categorized under the ancient classification of res mancipi.
Res mancipi, what did that include?
This ancient category included things like slaves, draft animals, think oxen and horses needed for farming and, critically italic, lands, land in Italy itself. These were seen as the core, irreplaceable assets of the traditional Roman agricultural and aristocratic family, the foundation of their wealth and status.
Okay, so how did the law make sure these specific critical assets couldn't be casually or, fraudulently liquidated by a greedy or incompetent guardian?
Right. Alienation. That is, the transfer or sale of res mancipi required a special, solemn, formal process called mancipatio.
Mancipatio.
This was not a simple handshake deal or signing a piece of parchment. It was a public ritual requiring immense visibility. It had to be performed in the presence of at least 5 witnesses, who had to be adult male Roman citizens. Plus, you needed a 6th person, the libripens, literally, the scale holder, who held a set of bronze scales and a piece of bronze metal which symbolized the price, even if the real price was different.
So the act of transferring the family farm, or a key group of slaves, it was essentially a public performance with witnesses and scales and everything.
Precisely. It was a formal, public acknowledgement that significant ancestral wealth was changing hands. For a guardian to legally alienate res mancipi belonging to his pupillus, they would have had to perform this solemn rite. This made it incredibly difficult to do so secretly or carelessly. This formal requirement really demonstrates how Roman law treated the transfer of ancestral wealth not as a private transaction, but as a high-stakes, almost dynastic event necessary for family and societal continuity. It effectively acted as a kind of dynastic firewall against casual or corrupt transfer of key assets.
That's fascinating. And finally, the Roman system was so proactive about protecting the lineage and property that it even addressed the rights of a child who hadn't even been born yet when the father died.
Indeed, the system had a specific mechanism for the necessitores, the unborn child conceived but not yet born. The praetor, who was the magistrate largely in charge of equity and developing law, could protect the child's expectation of being born and inheriting. He did this by granting bonorum possessio, which is essentially legal possession of the estate's property, to the pregnant woman on behalf of the unborn child.
So it secured the estate's future while awaiting the birth.
Exactly. It put things on hold legally, protecting the potential heir's share.
That seems necessary, but also potentially open to abuse, doesn't it? I mean, did Roman jurists anticipate someone potentially claiming pregnancy falsely just to gain temporary control over the estate or delay its distribution?
Oh, absolutely, they thought of that. And this is why strict requirements were put in place. The woman had to genuinely be pregnant both at the moment of her husband's death and at the time she formally requested this legal possession. Jurists actually had procedures, sometimes involving physical examination by midwives, to verify the claim. It wasn't just taken on her word.
Wow, okay. Verification?
Verification.
Yeah.
Furthermore, because managing an estate for a potentially large and technically unknown number of future children from one pregnancy was administratively impractical. I mean, what if she had twins? Triplets.
Right. How much do you set aside?
Exactly. So the jurists placed a practical legal limit on this expectation.
What was the limit they imposed? How many potential heirs did they account for?
They decided, based likely on observation and perhaps medical understanding of the time, that a maximum of 3 portions of the inheritance would be held back for a child or children expected from a single birth.
3 portions.
3 portions. This was seen as a pragmatic boundary. So if the woman subsequently gave birth to quadruplets, legally only 3 portions would have been formally reserved in this specific way before the final distribution of the estate. It shows the legal system trying to balance the sanctity of life and lineage with the practical necessity of administering the existing assets in the interim period before birth.
Okay, let's step back and look at these 2 systems side by side now. What really stands out, for me at least, is that constant agonizing tension they both faced. The person best suited to protect the child's interests, usually the closest family member, was also often the one with the most to gain personally from the child's failure or the estate's mismanagement.
It is the inherent risk, isn't it? The risk of entrusting patrimony to kin. And it's a risk that Athens seemed more willing to absorb, perhaps relying more on social morality and honor.
Which often failed.
Which, as the sources show, often failed. Whereas Rome treated that risk almost as a certainty, something that needed active procedural management. In Athens, that reliance on close agnates, particularly the paternal uncle, led directly to those documented disputes and the frequent maltreatment of orphans we talked about. The Athenian legal system felt reactive, constantly struggling to police kin who were failing their moral and legal duties to the oikos. The law often had to chase the theft after it occurred.
Whereas Rome, as you said, seemed to build its system almost assuming the guardian might fail. The response wasn't primarily relying on morality, but on these incredibly detailed financial recovery mechanisms.
Precisely. The Romans didn't necessarily try to eliminate the risk of malfeasance among kin. Maybe they saw that as impossible. But they constructed this incredibly detailed administrative architecture designed specifically for financial recovery, prioritizing the action on tutelage against the guardian, even if insolvent, before going after the outside party with the Actio Doli shows a legal system structured to make the financial risk stick to the guardian, not easily transferable away from the minor's estate. They built mechanisms like restitutio and integrum to ensure that even when the guardian failed or the minor made a mistake, the money or property would ideally eventually come back to the pupilless.
And if we connect this to the bigger picture, it really forces us to recognize that these laws weren't simply about the welfare of a vulnerable child, although that was certainly a factor. They were actually a crucial structural mechanism for securing the financial and social fabric of ancient life itself.
Absolutely. That's the bottom line. The survival of the family line, the preservation of the family estate, this was the very foundation of early society, especially complex ones like Rome. The entire structure of political and economic power was built on this fundamental assumption of shared lineage, of descent. When a wealthy paterfamilias died, if his estate just dissolved or was frittered away, the social status of that entire lineage could dissolve with it. Therefore, managing the estate of the minor wasn't just about the kid, it was fundamentally about maintaining dynastic stability for the state itself.
And the importance of this dynastic stability is almost physically represented in how property, especially key property, was moved. We talked about mancipatio.
Yes, exactly. That specialized, solemn ritual of mancipatio required for transferring res mancipi, the core ancestral wealth like land and slaves, it underscores this point perfectly. Roman law didn't treat the alienation of a piece of Italic land like, a simple sale of grain down at the market. It treated it as a public, formal, highly witnessed act necessary for family continuity and, by extension, societal continuity. The state was deeply invested in ensuring the continuity of these wealthy landholding households, and these legal rituals acted as tangible barriers against the casual or corrupt dispersal of inherited wealth.
So if we step back and try to summarize this deep dive, what does it really reveal about these two great powers and their approach to this common problem?
Well, I think it shows Athens, perhaps driven by the strong cultural mandate of the kyrios and those deep agnatic ties, relied very heavily on the morality and honor of kinship. But this left the property and the orphan highly vulnerable to kin-based exploitation when that morality failed.
A system built on trust that was often broken.
You could say that. Rome, in contrast, built this intricate legal and bureaucratic framework. The tutor, the pupilless, the detailed procedures like restitutio and integrum and sequenced actions. It was designed not just for abstract justice, perhaps, but for very pragmatic financial risk management and property recovery, making sure the wealth stayed where it was supposed to.
So the final takeaway here, maybe, is that these intricate laws concerning orphans and guardians, they weren't some kind of humanitarian afterthought tacked onto the legal system. They were a foundational structural mechanism. They were designed to ensure that property and social status survived the potentially catastrophic death of the patriarch, reinforcing the ancient state's deep, practical investment in dynastic stability across generations. It was almost like Social Security, but ancient style, focused on the wealthy families.
Yeah, at the end of the day, it was about ensuring continuity, often secured, as we've seen, at great procedural cost and complexity, especially in Rome.
Right. Now, we discussed how Roman law protected the unborn child's claim to inheritance, going so far as to require the pregnant woman to actually demonstrate her condition to the state and jurists, and even capping the legal expectation of births at 3 portions to allow for practical estate management. This leaves us with a final provocative thought for you, the listener, to consider. What does that requirement that a woman might have to prove her pregnancy to the state, effectively surrendering a major part of her bodily privacy? What does that reveal about the limits of personal autonomy when family property and lineage are considered the absolute core stabilizing forces of society? Where does the state's interest end and personal privacy begin in that kind of world?